appeal in the matter of Lufthansa Technik AG and Astronics Advanced Electronic Systems and others.
Yes, Mr. Campbell.
May it please you, my lords, I appear in this matter, my learned friend Mr. Hall, for the appellant and claimant Lufthansa, and my learned friends Mr. Mitchton, Mr. Copeland and Ms. Hart appear for the defendants and respondents. Lufthansa has two applications for permission to appeal before the court, and they represent two routes by which Lufthansa seeks permission to deploy certain infringement allegations at the trial of accounts of profits against the defendants. Those allegations had been expressly adjourned to the quantum stage by orders of Mr. Justice Nugee and Mr. Justice Marcus Smith well in advance of the trial, which took place before Mr. Justice Morgan in July 2020. The allegations have been called the adjourned issues in the written materials before the court, and I will use that definition. Now, at that trial, after that trial, Mr. Justice Morgan made an order for relief, which I will call the trial order, dealing with post-trial matters in the usual way. And at a hearing in April of this year, Mr. Recorder Campbell, KC, sitting as a Deputy High Court judge, was required to construe that order. And he construed it as precluding Lufthansa from taking up the adjourned issues at these accounts, whilst at the same time allowing them to assert other unresolved issues, which I will call the unresolved issues, at those accounts. And we seek to appeal that decision today. And that's my first route, which I will call the construction appeal. The second route involves the assumption that the deputy judge was right in his interpretation of the trial order. And if that's right, we say that that order was one which the trial judge ought not to have made. My application for that appeal against the trial order is out of time, so relief from sanctions would be required, and I will call that the trial order appeal. There was a third route too, but that has already proved demonstrably unsuccessful. That was an attempt to persuade Mr. Justice Morgan to vary the trial order. My lords, there are two dichotomies that are at the heart of these appeals and these applications, and it may help to have them in mind as I work through my submissions. The first is the split between liability and quantum. As we will see, there is an ambiguity that arises repeatedly between the two, in the judgments, the orders, and the submissions. So a key question will be, were these various documents just addressing the liability stage of these proceedings, or were they also addressing the quantum stage? And I will be suggesting that there's a consistent answer that was recorded in terms in the original trial judgment of Mr. Justice Morgan, which is that they were only addressing the liability stage. Even if that's wrong and some greater uncertainty subsequently developed, we say that that uncertainty cannot justify the consequence that has presently been visited on Lufthansa. A modest degree of ambiguity does not cause the loss of valuable claims. Now, the second dichotomy is between the adjourned issues and the unresolved issues. The adjourned issues were never before the trial judge. On the other hand, there were some additional infringement issues that he did not decide, and the relevant evidence was led at trial in relation to those issues, and the judge received full submissions on them, but he didn't resolve them. And in the judgment of the deputy judge, they are called the unresolved issues. Now, as we will see, things have turned out very differently for the adjourned issues and the unresolved issues, and we say there's no proper justification on the facts of this case for such different outcomes. And that, we say, is a powerful indication of the erroneous nature of either the construction judgment or the original trial order. Now, before turning to the subject matter of the appeals, it may help if we orientate ourselves with respect to the defendant's activities and the trial judge's decisions about that activities. And if I could start with the trade that we are concerned with, my lords, take the core bundle and turn behind tab 5 to page 35. This is my learned friend's skeleton, which includes a helpful diagram under paragraph 12. The patent in suit was for a power supply.
Before you embark upon this, what are you showing us this in order to illuminate?
So that you can understand the manner in which the three defendants dealt with components and parts in a different way, so you can understand the different infringement issues that arose in relation to them.
Thank you.
So the patent in suit was for a power supply which is used by passengers on an aircraft cabin, and the patent, we know, is valid. The assembled product, once it's all put together, it's called an M-Power system, is a product falling within Claim 1 of the patent. But the web...
I'm not sure it matters, but is it the M-Power system as a whole, or what I'll refer to in this document as the primary components?
It's the primary components. If you put the primary components together, that's enough to get you a power supply as per Claim 1 of the patent, as construed by the trial judge. So the multiplicity of issues arose because there is a distinction between a power supply on the one hand, when it's all joined together, and the components that can be put together to make a power supply on the other. So if you look in the top left of that diagram, you'll see Astronics, and it's Astronics who makes these components in the United States. And then you see two arrows emanating from Astronics, and both are labelled M-Power components, because Astronics only distributes these products in component form. And if we go down the left-hand green side, we see that some products, some components are provided to seat manufacturers in the UK directly by Astronics. And Safran, which is the third defendant, is an example of a seat manufacturer in the UK. On the other hand, if we follow the right-hand blue arrow horizontally across the top, we see that some are given by Astronics to Panasonic in the United States. And then Panasonic, in turn, provides those components to seat manufacturers in the UK. Now, there was no issue at trial about how these products actually functioned. And in those circumstances, there was no difficulty in establishing Safran's liability, because Safran was actually putting them together. And so Safran took components and made a power supply, which is an act of infringement under Section 60, sub 1 of the Patents Act. The other two defendants originally both denied liability. And the most straightforward route to pinning them with liability was under Section 60, sub 2 of the Patents Act, which is often called contributory infringement. And Section 60, sub 2 says it's an infringement to supply, and then I quote, means relating to an essential element of the invention for putting the invention into effect, knowing that those means are suitable for putting and are intended to put the invention into effect in the UK. Now, at trial, it was common ground that these components were means relating to an essential element of the invention. And by trial, Astronics had admitted that it had the relevant knowledge, but not so Panasonic. Panasonic's position was that it knew that the components it handed on were going to be assembled together, but it claimed that it was technically ignorant about the contents of the boxes of components that it received from Astronics and passed on to its own customers. And as a result, it denied contributory infringement on the basis of the lack of the necessary knowledge element. Now things get slightly more complicated, because that question of knowledge then became split into two parts. This was as a result principally of the pandemic. The first part was a question of law. what type of knowledge is sufficient to satisfy section 60 sub 2? Was it enough that Panasonic knew the commercial destiny of the parts that it was supplying? That commercial knowledge was admitted by Panasonic in its product and process description, and it was our position that as a matter of law, that was sufficient. The defendant said it was not, and that was an issue before the trial judge, that issue of law. Second, there was a question of fact. Did Panasonic, in fact, have the technical knowledge of the manner in which those parts fitted together and functioned? That, it was accepted, was sufficient to give rise to contributory infringement, but as I've said, it was denied on the facts. Now, that factual issue could only be resolved by cross-examination of the Panasonic witnesses who spoke to this technical ignorance. And because we didn't want any more witnesses at a trial taking place during peak pandemic, it was adjourned so that they wouldn't have to travel to solicitors' offices, etc., etc. So the technical, factual knowledge became an adjourned issue by consent in advance of the trial. If we could then pick the story up in the liability judgment of Mr. Justice Morgan, this is the supplementary bundle, tab 23. So the learned judge starts dealing with infringement at page 148 of the bundle, and he sets out paragraph 274, the 5 primary components that my Lord Justice Arnold just asked about, and he says that the defendants deal with them in different ways. He deals with Astronics at 276 and 277. 277, he says, Astronics supplies components. The components are means relating to an essential element of the invention, and Astronics admits that it had the knowledge required. So by trial, there was no problem with Astronics. Safran, he says, at 278, is making the products and is therefore a direct infringer. Then he introduces the position with Panasonic at 279. At 280, he says, Panasonic submits it's not liable for direct infringement because it does not assemble the components into the system. That's done by its customers. Further submits that it's not liable for indirect infringement under section 60 sub 2 because it did not have the knowledge required for liability. Plainly, Panasonic knew a great deal as to what was intended to be done with the components it supplied, but it says that it was unaware from a technical standpoint of the operation of the system. Pausing there, the judge has identified the 2 strands of the knowledge issue, the question of law, the commercial destiny of the components, and the question of fact, Panasonic's technical knowledge. And at 281, the judge records that Panasonic's stance has led Lufthansa to assert infringement in a number of different ways. First, as a matter of construction of Claim 1, that argument he's already rejected. Then over the page at Roman 2, by reference to the kit of parts doctrine, Roman 3, by reference to the doctrine of equivalence, Roman 4, because technical knowledge is not required for section 60 sub 2, the commercial knowledge was enough. And then a 5th route is recorded in paragraph 282. That Panasonic had a common design with its own customers to make infringing power supplies. And it was that 5th route that the judge held was made out. Now, there's an important distinction, it's important with the benefit of hindsight, between that 5th route and the other 4. The 5th route involves the infringing act being carried out by Panasonic's customers and not by Panasonic. That distinction was immaterial at the liability trial in July 2020, But if we consider the current defence in the account of profits, it matters a great deal. Lufthansa has elected for an account of Panasonic's profits, and Panasonic has made handsome profits from this trade, if I can put it broadly. But Panasonic says none of those profits were accrued from its common design with its customers. One can see that from the core bundle, tab 23, page 172. Paragraph 20. We understand Panasonic's position to be that its profits were accrued when it supplied the components to its customers, and therefore they were all banked already, notionally, before the customers even put the parts together. Now, that supply of components was alleged to be infringing by reference to the 4 alternative infringement routes which Lufthansa asserted at trial, and indeed one of the adjourned routes. Now, back in the liability judgment, we come to the critical part for the purposes of today's appeals. So this is supplemental bundle, tab 23, page 151. Because in paragraph 286 of the liability trial judgment, the trial judge explains why he left those issues unresolved, those 3 issues that were before him. We're not talking about the adjourned issues now, we're talking about kit of parts equivalence and means essential with commercial knowledge. So 286, he says, accordingly I conclude that Panasonic is liable by reason of its common design to do acts which amount to an infringement within section 61A. That conclusion means that it is not necessary in this case to consider the further arguments which the claimant has put forward. Pausing there, my lords, that is the judge's own decision that he did not need to resolve the 3 other infringement issues before him, these 3 unresolved issues. And it is clear, we will submit, that in the context of the adjourned issues, that conclusion finds its way into the 4th recital to the trial order. And I will come on to show you that progression. Now, the judge says it is not necessary, but that rather begs the question, necessary for what? Does the judge mean necessary for the liability stage alone, or necessary for the whole of the rest of the proceedings? That is to say, including the quantum stage. Now that, my lords, was my first dichotomy, and the answer to that question provides the key context for all that follows. And we suggest the answer is pretty obvious. He had in mind this liability stage and this liability judgment alone. He cannot possibly have been deciding whether these issues might be relevant to the quantum stage. He received no submissions whatsoever about what any quantum proceedings might look like. It was far too early for him to do so. And he's received no evidence about how Lufthansa plans to deal with those issues in future. All he is saying here is that Lufthansa has established that Panasonic bears some liability for patent infringement, and that in accordance with established procedure in the Patents Court, that is enough for a liability trial.
You mean quantum?
Well, it's enough to give effect to an award of a quantum trial.
It's enough for a finding of liability and therefore opening the way to a quantum investigation subsequently.
Indeed, indeed. It's all he needed to do following a liability trial.
Yep.
Now, picking it up then back in paragraph 286, the judge refers to my closing oral submissions, and he says, I invited him to decide the case against Panasonic on this basis and not deal with the other arguments. Now, what I actually said was that if he found Panasonic liable on this basis, he, and I quote, did not need to touch the knowledge point. And for my Lord's notes, that's supplemental bundle tab 49, page 315, transcript page 841, line 5. Now, as I've explained, the knowledge point was an issue of statutory construction of section 60 sub 2 of the Patents Act. And I think, to be fair to the judge, he hadn't shown a great deal of enthusiasm for deciding that point if it wasn't necessary. And all I said was that he didn't need to decide it if he found Panasonic liable on this basis. I did not say that Lufthansa would abandon the allegation, never to revisit it. I did not say anything about the quantum stage. That would, of course, have been absurdly presumptuous in closing submissions at a liability trial. So we say, when the judge talks of deciding the case against Panasonic, he means deciding the liability issue that was the subject of the trial, and that is all. And as we will come on to see, the learned deputy judge, Mr. Recorder Campbell KC, makes a critical finding to that end. Back in paragraph 286, the judge repeats, I agree that I ought not to deal with the other arguments. A decision on those points is not necessary in this case. So that is the trial judge himself saying, additional infringement arguments do not need to be decided. So, my lords, that was the position following trial with respect to the unresolved issues. Now, we've set out in our skeleton argument, which is core bundle tab 4, paragraphs 8 to 11, how the adjourned issues were treated prior to the relief hearing. I don't need to go through all of that. For present purposes, you just need to note that the adjournments were ordered in the context of express representations that issues would be available at the quantum stage, and that the trial judge himself was told this in terms in the defendant's written submissions. I do want to mention the nature of the adjourned issues. If we are right about any of them, and of course they haven't yet been considered by any judge, the result is that Panasonic is liable for its own acts of supply and not just its customers' acts of manufacture. Now, to put that in context, the patent in suit is a property right belonging to Lufthansa, and the Patents Act gives Lufthansa a legal right to relief for these acts of infringement. That includes, amongst other things, a legal right to damages. So these claims, these unresolved claims, are akin to property rights, and they need to be treated accordingly by the courts. And that position is reflected in our skeleton argument, where we say that an arguable civil claim may be struck out as an abusive process, or because it is res judicata or limitation barred, but otherwise it should be allowed to go forward to trial. It should not be set aside as a matter of mere case management. Now, my lords, at this point, you would be forgiven for falling prey to some uncertainty as to the distinction between these various unresolved issues and adjourned issues, and there is a helpful table, which I can take you to now, at the back of the judgment of the deputy judge. So this is Core Bundle tab 18. Page 135, and it goes over to 136 as well. If I could just show you, talk you through that. Left-hand column, second row, you'll see the heading Panasonic, and then the second column is headed Trial Infringement Issues. The third column is labelled Determined Issues. Now, if you look down that column, you'll see there's a red box aside one of the issues in respect of each of the three defendants. And that reflects the trial judge's entirely conventional approach of deciding that each of the defendants was liable on at least one basis and not deciding any more. I think properly that the square to the left of each of those red boxes in the trial infringement issues should probably be yellow, because of course those decided issues were also trial infringement issues. The fourth column is titled Abandoned Issues, and you need to make a note in relation to that. That title was highly tendentious, and as we will see, the deputy judge decided these issues had not been abandoned at all, and so you can usefully rename that Unresolved Issues. And so if you look at those unresolved issues, you'll see the first two issues listed there were kit of parts and equivalence. The third issue is supply of components PPD knowledge. That is the section 60 sub 2 contributory infringement case based on commercial knowledge which was admitted in the PPD. And we've just seen Mr. Justice Morgan stating in terms that he did not need to decide those issues. And then the fifth column is the adjourned issues, and you'll see, for example, the first one, first blue box, is supply of components section 60 sub 2. That refers, it's not entirely clear from this, but that refers to contributory infringement case based on Panasonic's technical knowledge. So that's the case that was adjourned, so we could avoid having additional fact witnesses at the trial.
You've already explained what you say the significance is of that issue to the account profits. What about the other two, the ones relating to Safran and Astronics?
So I think the one relating to Safran has less significance. The one relating, it's numbered 11, relates to the dealings between Astronics and Panasonic in the United States prior to Panasonic's supply of products to the UK. So the argument is that in effect there's no reason to distinguish between Astronics and Panasonic in this regard. As I understand the position on the documents, Panasonic has a corner of a warehouse in Astronics US facilities where the Panasonic parts are put, and then from there Panasonic arranges their onward movement to the seat manufacturers in the UK. So what the claim is that that's a common design between Astronics and Panasonic in the US to supply to the UK seat manufacturers, and that is not covered anywhere else in the quantum claim. So that is a matter of some significance.
You said that the issue with regard to Safran was, I think the way you put it, was of less significance. Is that a way of saying no significance?
No, I'm not. I don't accept it's of no significance. I think it's a little bit more nuanced. But if I could take a moment, instructions
Yes,
just for a
by all
moment
means.
in relation to that. Great. My learned instructing solicitor reminds me that a similar profits argument is being run by Safran, that they don't make money from their acts of manufacture and that they make it from disposal instead. So there's a sort of slice and dice going on with respect to the activities and the allotment of profits to those activities. So, my lords, the state of play following the decision of the deputy judge, the learned deputy judge, is that Lufthansa is permitted to assert the fourth column yellow issues, but it cannot assert the fifth column blue issues. And that inconsistent outcome is the subject of my second dichotomy. We say the difference in the treatment of the two categories of issues makes no procedural sense. And in particular, Lufthansa is...
Sorry, could you just rerun that again?
Yes, of course. So the...
Do you say... I thought you said permitted to run unresolved.
Yes.
Not permitted to run adjourned.
Correct. My lord, that was my second dichotomy between the unresolved issues on the one hand and the adjourned issues on the other. And to make the slightly absurd current position clear, we're allowed to assert at the quantum stage that Panasonic is liable because it had commercial knowledge and is liable for, under section 60 sub 2, so that the contributory infringement based on commercial knowledge, that goes forward to trial. But the claim that they had technical knowledge, we're not allowed to take forward. So the same statutory basis, but two different parts of the same consideration. We can run the legal case, but not the factual case, even though the only reason we didn't have the factual case at trial was to avoid calling witnesses at a pandemic trial. And we say that does not accord with the fair treatment of Lufthansa's legal rights. Now, in order to explain this argument, we need to see how things played out for the yellow unresolved issues. The first point to note is what happened to the costs of those issues. There was no dispute after the liability trial that Lufthansa should have its costs of the unresolved issues, even though the judge had not decided them. That is important, as we shall see. It was therefore common ground that the mere fact that a liability issue had not been decided did not mean that the costs of that issue would not follow the overall outcome of the liability stage. And that proposition in and of itself goes a long way to meeting my learned friend's argument that Lufthansa must have abandoned the adjourned issues because it sought and obtained a costs award in relation to them. That simply doesn't follow, and we know it doesn't follow because that isn't what happened with the unresolved issues. There is also a significant nuance in the question of costs and the destination of these various issues. The position after trial was, we maintain, that it was unlikely that any of these issues would come back at the quantum stage. And in particular, if Lufthansa had elected for damages, which is a far more common election than profits, it seems they would not have come back. And even now, my lords, it is not the position that Lufthansa wants to rely on all the adjourned issues. We do not seek to assert the allegation of joint tortfeasance between Safran and Astronics, and we do not seek to assert what was called the bait and switch argument against Astronics. So in that context, grasping the nettle of costs, as the judge did, was both conventional and sensible.
You said it's not the position that Lufthansa wants to rely on all the adjourned issues.
So what you've seen in the table I just showed you, that represents the unresolved issues and the adjourned issues that we know, because I've tried to plead them, that we want to take up again. But it's not everything. So it is the position.
When you said you don't want to rely on all the adjourned issues, is that what you really mean?
Yes, that's what I
So which
mean.
is
So,
which
but
of the
that's what
three is it that you're not relying on?
In other words, what we're being told is the table is incomplete.
The table represents those that are in issue because Lufthansa wants to reprise them. There are others which Lufthansa does not want to reprise.
I understand, thank you.
So it is incomplete, but it was fit for the purpose for which it was designed. But I don't want to give you the impression that there wasn't good reason. Well, I want to give you the impression that there was still good reason for the judge saying, well, look, I'm going to decide what I can now in relation to costs after the liability trial.
This table was the one prepared by the defendants, but was preferred by the judge, except for the heading abandoned.
My lord, yes.
Yes.
Could we then turn back in the judgment of the learned deputy judge to see what he did about the unresolved issues? If we could start, please. So this is core 18, paragraph 6, page 122. So in paragraph 6, sub 1, you'll see the passage that my Lord Justice Phillips was just referring to, where the deputy judge renames those issues. And then starting in his paragraph 8, he deals with the position as he sees it, independently of the terms of the trial order. He starts with the legal context. That's paragraphs 8 through to 20. And then he analyses, you'll see at 21, I will ignore the effect of Morgan Jay's order following trial at the moment, since that is the next issue. He sets out the facts. And you'll see at paragraph 25, he quotes in full paragraph 286 of the trial judgment, which I have just taken you to with some care. And then his conclusion at paragraph 29 is this: leaving the effect of the final order to one side, I can see no reason why it would be either just or convenient to prevent Lufthansa from raising any of the further allegations of infringement which it seeks to raise on the account. In fact, reasons of justice and convenience point the other way. Now, it made sense to leave aside the effect of the trial order because it says nothing about the unresolved issues, apart from impliedly awarding Lufthansa its costs. The costs point is one he notes at subparagraph 9 on paragraph 128, and he says correctly that nothing turns on it. So at this point, my lords, he has decided that justice and convenience point to allowing Lufthansa to raise both the unresolved issues and the adjourned issues. And going back to his reasoning just further up the page in paragraph 29, he relies expressly on the circumstances of the pandemic and the parties seeking to reduce the scope of the trial. That's subparagraph 1. And for present purposes, subparagraph 3 is critical. He says, it is true that Lufthansa did not complain to the judge about his comments in paragraph 286 when receiving the judgment in draft. However, I do not read the judge as saying there that Lufthansa was prevented from raising the other arguments at the stage of quantum. The judge was not dealing with quantum at all. My lords, that is obviously right. When Mr. Justice Morgan held that the unresolved issues did not have to be decided, he was talking exclusively about the liability stage. And it's our position that this same circumstance applied to all the relief evidence and the submissions, and most importantly, to the trial order. In effect, nothing changed between paragraph 286 of the trial judgment and the trial order. There's one other point to note about this decision. It does not rely in any way on the provision of express liberty to apply. So what the deputy judge has said is, without any permission one way or the other, the state of the law is that if it's just and convenient, you can revisit undecided issues, and it is just and convenient. You don't need express liberty to apply. Now, there is no appeal from this outcome regarding the unresolved issues, no challenge to the deputy judge's reasoning. And I want now to go to the trial order and explain why it provides no warrant for treating the adjourned issues any differently. The trial order is behind tab 15. It starts, my lords, with 5 recitals, and they do what recitals are meant to do. They set out the context for the operative parts of the order, and they record relevant developments which predated the decisions that are found in the operative parts of the order. And in accordance with good practice and good sense, they are in chronological order. The first recital records the pre-trial orders adjourning the adjourned issues in January and May 2020. The second recital records that the other issues were tried before Mr. Justice Morgan between the 22nd of June and the 1st of July. Now, of course, that includes the unresolved issues, which were tried but not decided. The third recital records the handing down of the judgment on the 22nd of July, and that is also important because the trial judgment states in terms what has happened to all the trial issues. Some have been determined, and those that haven't, as we've already seen, the judge has said is held, no decision is necessary. Because that outcome is recorded in the trial judgment, it does not need to be independently recorded in a recital to the order. On the other hand, the trial judgment says nothing about what's happening to the adjourned issues. So that is dealt with in the fourth recital. And it's the fourth recital which is the foundation of the Deputy Judge's decision. We need to look at it carefully, but before we do, first note please the fifth recital. Again, working through this in chronological order, the fifth recital records that there have been further developments, matters consequential, written submissions, determination by the judge. So on the face of it, that is something that has happened subsequent to the fourth recital. Now, in our skeleton argument, we relied in the main on the terms of the agreed draft order that was before the trial judge. My learned friend's response is to rely repeatedly on this fourth recital, which is, of course, what the Deputy Judge did too. So I plan to meet that challenge head on and argue our position based on this fourth recital. So what does it say? It says, and upon the adjourned issues no longer needing to be determined in light of the court's judgment. The recital comes in two parts. The first part is the outcome, and the second part is the cause of that outcome. The outcome is the adjourned issues no longer need to be determined. My lords, that outcome is identical to that set out in paragraph 286 of the trial order regarding the unresolved issues. This is not saying that there is any different conclusion than the cause, what has brought about this situation, in light of the court's judgment. This is not said to be the result of some representation by Lufthansa in evidence or submissions. It is said to be exclusively the result of the court's judgment, and that, we submit, is why it's found here in the fourth recital, after the judgment has been handed down and before consideration of consequential matters. Of course, the court's judgment was also the cause of the unresolved issues no longer needing to be determined. So if we take this recital together with paragraph 286 of the judgment, we reach a common position.
Well, just before you move on to that, I'm a little puzzled by your chronological presentation of the recitals, because we know that the fourth recital was itself an issue before the judge, which he determined in the consequentials judgment.
Yeah, absolutely right.
So how can you say that the fourth recital is logically precedent to the fifth? It's not. It's all part of the same, isn't it?
Well, no, I can and do say that. Firstly, I say it, leaving aside the judgment to which we will come. If you just look at the order, then that's what the order says. On its face, it goes through in a chronological order. It attributes this outcome exclusively to the judgment. So there is no conflict between my submissions and the terms of the order. What my lord is putting to me is that, but we know things didn't quite work out like that. And the answer I give my lord is this. After there was debate about the appropriate form of the order, the judge resolved that debate by, in effect, saying, I'm going to limit this to the consequences of my judgment. So he renounced the effect of any further developments, and he put in place a scheme under which the fourth recital simply limited the consequences to those set out in the judgment.
All right, well, I understand that submission, thank you, but then that leads to the next problem, which is that we know from the judge's judgment that that's not, in fact, his process of reasoning. Because when you look at the judgment, his process of reasoning is not that it all flows from the judgment. On the contrary, his process of reasoning is that it flows from a combination of the judgment and the submissions made to him after judgment.
So my submission will be, and we are going to come to the judgment, that it's not as clear as that. And if you read the judgment as I will invite you to do, with paragraph 286 in mind, then what you actually see is he's not doing anything different. He is recording some submissions one way or the other, not entirely clear what he thinks about those submissions, but what is clear is what he decides to do about it. And what he decides to do is effectively align the position of all the undecided issues. He decides not to go beyond the position recorded in paragraph 286. That, we submit, is the objective meaning of the judgment and the objective meaning of this order. Can we look then, please, at the decision of the Deputy Judge in respect of the adjourned issues? So this is core tab 18, and we start in paragraph 30. The decision comes in two stages. First, the Deputy Judge refers to the trial order, and he reaches a preliminary conclusion on that. And second, he goes to the trial judge's relief judgment and decides that that is consistent with his initial conclusion. I'm going to explain why we submit that both analyses were wrong. If we could start, please, in paragraph 34, which is the judge's analysis. He says there that the starting point is what the order says, and we agree. And he says, by far the most important consideration is the words of the order. Again, we agree. Paragraph 35, he records that the trial judge ordered that the defendants should pay Lufthansa's costs of the adjourned issues. That is true, but as I've already mentioned, he also ordered them to pay Lufthansa's costs of the unresolved issues. And 2 pages earlier, in paragraph 29.9, the Deputy Judge had held that nothing turned on the cost point. So this cannot be a reason to treat the adjourned issues differently. Moreover, Lufthansa had in its application undertaken to repay any of the costs of these issues if ordered to do so. In paragraph 36, he comes to the fourth recital. He starts by agreeing with me that there is no order refusing liberty to apply, but he then discounts that absence. He says that the fourth recital, and I quote, implies there is no such liberty in paragraph 11, since none would be needed for issues which no longer needed to be determined. And it is on that basis of this implied effect, that the Deputy Judge rules that this order prevents Lufthansa from raising the adjourned issues on this account. There are 2 errors in this assessment of the fourth recital. First, the reasoning is entirely circular. The ambiguity in the fourth recital relates to my first dichotomy. Does no longer needed to be determined refer to just the liability stage or to the quantum stage 2? And the Deputy Judge has here resolved that ambiguity exclusively by reference to the words no longer needed to be determined. As a matter of logic, that cannot represent a legitimate reason. Second, and perhaps more fundamentally, he's wrong about the fourth recital and my first dichotomy. I've already explained how it works. He has overlooked the clause in the light of the court's judgment. He's overlooked where the fourth recital comes in the chronology. He's overlooked paragraph 286 of the trial judgment, which says what is meant by do not need to be decided, no longer need to be determined. And he's overlooked his own reasoning in paragraph 29.3 that that judgment said nothing about the quantum stage. So it is wholly inconsistent for the deputy judge to record that the trial judge was saying nothing about the quantum stage in paragraph 286 when he said, well, these issues don't need to be determined. But then, when it comes to the fourth recital, he's talking about the quantum stage. When he's describing what needs to be done in light of the judgment. Doesn't make sense. We suggest there is a better view, which is that throughout this, no one has given any thought to the quantum stage, which is not at all surprising. No thought to what issues might or might not be taken up at that stage. We haven't had any island and Tring disclosure. No one's given any thought to an election yet. And all that is happening is that everybody is wrapping up the liability stage, and nothing more than that. But moreover, as I pointed out, the deputy judge's decision in paragraph 29.3 is not challenged. And if that's not challenged, my learned friend needs to explain why those same words mean something different as between the trial judgment and this recital. The deputy judge didn't simply rely on the recital, he also relied on paragraph 11 of the trial order. And in order to explain my position on that, we need just to turn forward to see what he said the consequence was. And you see that consequence in paragraph 49 of the judgment on page 133. He held that the trial order prevents Lufthansa from raising the adjourned issues of the account, and that Lufthansa, if it wants to raise the adjourned issues, needs to appeal against the trial order. So we're dealing now with paragraph 11 of the trial order, which, for your convenience, is recorded on page 130 of this judgment, just above paragraph 35. The parties have liberty to apply for further directions on the inquiry and account. And we have three complaints about the deputy judge's decision here, and they are ordered. Our primary case is that the deputy judge has failed to take account of what the trial order would have to say in order to bring about the consequence that he's recorded. We are concerned here with properly pleaded allegations of infringing liability and with legal rights under the Patents Act, which Lufthansa is seeking to assert. There's been no decision about them, they're not unarguable or an abusive process. In order to give effect to that outcome, it is our submission that the order would have to record either that the judge had struck out these issues for some reason, or that Lufthansa had voluntarily dropped them, deleted them from its claim. But the order does neither of those things. If we're wrong about that, then our secondary case is that the deputy judge has not taken proper account of the prior orders for liberty to apply. Those orders were for the benefit of Lufthansa. Lufthansa secured safe passage for the adjourned issues through to the quantum stage. And the prior orders are expressly cross-referenced in the first recital. If that safe passage, those benefits, were to be set aside, there needed to be countervailing express wording. You can't acknowledge the existence of those benefits expressly and then, in what is in effect the same document, impliedly set them aside.
I'm sure you're entirely correct about the way you characterise the prior orders, but nevertheless, I don't think you've shown them to us yet. So, should we not have a quick look at them?
Very good. So, the easiest way to do that may be from my skeleton, because they're.
Do we not have copies?
We do have them.
Well, I think it would be best to look at the orders themselves.
So I will show you the orders. What you get from the skeleton is what went on before in terms of the correspondence that led to them. The reason that is relevant is that the correspondence expressly discussed adjourning to the damages or the quantum stage. But if you take that from me, and you can chase up the correspondence references in my skeleton if you wish to, or indeed if you want me to show you them.
Take your own course. Show us what we need to see.
Very good. Well, since my lord has asked, I will show you them. So this is core bundle tab 4, page 24. And you'll see paragraph 9, a quote from a letter on the 7th of May from my solicitors. Excuse me, I'm starting in the wrong place. That's the second one. Let me start with the first one. So what happened? The first tranche of adjourned issues were all joint defeasance issues, and we sought to introduce them in October 2019, at which time there was a liability trial due in February 2020, and the response from the defendants was that this may prejudice the trial date, and therefore it was the defendants who proposed that such issues would more appropriately be dealt with during any damages inquiry rather than as part of the trial in February 2020. And that was then agreed in correspondence, and the order of Mr. Justice Nugee is in the supplemental bundle, tab 17. Paragraph 7 on page 124. So 7A and B are joint tortfeasance arguments. 7C is actually what became the bait and switch argument, which has not been sought to be resuscitated.
It's not recorded as being by consent, but you say it was.
This was agreed. My lord is right, it's not recorded, but that was not an issue by the time of the hearing before Mr. Justice Nugee. I think what's happened is the matters above that were all.
Sometimes it gets forgotten about.
It was added on, and so that was actually nothing to do with the pandemic. That trial was adjourned because the defendant's leading counsel fell ill.
Sorry, I'm not sure this much matters, given what you've shown us already. But looking at paragraph 7, it's a little odd, because it says the following issues be adjourned with liberty to apply.
Yes.
But adjourned to when?
Right. So
I mean, it just seems to be a rather vague order.
that is a fair comment, which is why, my lord, I showed you the context for that agreement. The point being, whatever it means, it must have covered what the parties had in discussion, canvassed, which is adjourned to the quantum stage. Because that was the defendant's proposal. It's too much for this liability trial, so let's wrap it up in a damages inquiry, if there is one.
Yep. Thank you.
The second batch of adjournments did relate to the pandemic. As I've said, this is in particular the technical knowledge of the PPD, which would have required fact witnesses. And in my skeleton at core, page 24, you see that the letter of the 7th of May from my solicitors, we believe it would be sensible to limit the witnesses at trial to the 2 experts. The factual issue of the knowledge of the internal design of the product, which will require cross-examination of the PPD fact witnesses, can be left to the damages inquiry, if any and if needed, along with the contributory infringement and continuing offers for sale arguments, which were adjourned by Mr. Justice Nugee. Defendant solicitors agreed, and then the order to that end, this is the PTR order behind tab 19 of the bundle, of the supplementary bundle. If you have paragraph 7 on page 131, you'll see that the trial was limited to a scheduled list of issues, and all other issues, including the cross-examination of the PPD fact witnesses, shall be adjourned with liberty to apply. So, my lords, we say we had taken some care to shepherd those issues through, so they remained available to us, and we had express orders to that effect that were cross-referenced in the first recital of the trial order. And my second complaint about the judge's treatment of paragraph 11 is that if this outcome was to be visited upon Lufthansa, it needed express wording setting aside those litigation assets, those pre-existing liberty to apply. And there was none. And then my final and third case on the operation of paragraph 11 as per the Deputy Judge's judgment is that it's inconsistent with what he has held in relation to the unresolved issues. The premise for his decision here is that express liberty to apply would be needed if Lufthansa wanted to raise the adjourned issues at the quantum stage. But he has himself held that Lufthansa is free to take up the unresolved issues again. And there was no express liberty to apply in relation to them. So we say it necessarily follows from paragraph 21 to 30 of the Deputy Judge's own judgment that the court was free to manage the case and manage those issues in accordance with justice and convenience. And he made a finding about what that would have led to. So, to put it another way, there's no fetter on that in the words of the order. You can't find it in the absence of an express liberty to apply, because that would have covered the unresolved issues as well. My lords, I'm making good progress, and I was about to turn to the Deputy Judge's decision and the relief judgment. I wonder if that's, do you want to take a break for the shorthand writer, or should I just carry straight on?
We We will give the shorthand writer a break of 5 minutes.
Right.
Are we done by lunch or not?
Yeah. 2/3 of the way through, I think. Until they start. Until they open up. sleepy one. My Lords, I was going to move on to look at how the Deputy Judge dealt with the relief judgment as distinct from the trial order. So this is tab 18. He's reached his preliminary conclusion. And then he says at paragraph 38 that the judge's reasons are admissible to construe the order. Now, it's important when reviewing the relief judgment to distinguish between what the trial judge says about the parties' positions and what he says he has resolved to do in light of those positions. We suggest that there was perhaps a lack of clarity in the parties' positions, in particularly with regards to my first dichotomy, liability or liability in quantum. And in that regard, it surely didn't help that there was no oral hearing at which these matters could have been worked out. But we do say that the judge is clear about the action he will take. My Lords can follow it either within the judgment of the Deputy Judge, where all the relevant parts are, which is core 18, page 131, or if you prefer in the judgment, the relief judgment itself, which is core 16, page 112. In paragraph 2 of the trial of the relief judgment, the trial judge records that the claimant wants permission to apply in relation to the adjourned issues, and he considers that the request is tied up with the outcome of an appeal. He records that the claimant has not said that it would otherwise want to argue for a wider remedy than that which it is already entitled to. That comment about wider remedy is, we suggest, itself ambiguous, because of course the trial order gave Lufthansa an inquiry or an account, and success on the adjourned issues would not give rise to anything more than that. They wouldn't get multiple inquiries or accounts. So in that regard, they had a wide enough remedy to cover whatever might come out of the adjourned issues. Then in paragraph 3, the trial judge states his view that it is not appropriate for the order to provide permission to apply following a successful appeal. Now, that statement is also ambiguous according to my first dichotomy. Is he talking about permission to apply just at the liability stage? In other words, to have some sort of second liability trial? Well, the reference to an appeal suggests that he might be. But we submit it doesn't actually matter, because he then states with clarity what he's going to do. He says this: the order I will make will record the position following my decision at first instance. In accordance with that decision, the adjourned issues do not need to be determined. There are 3 points to note here. First, recording the position following the first instance decision is what one would expect a recital to do. Second, that is precisely what the fourth recital purports to do. And third, it is precisely consonant with the trial judge's position regarding the unresolved issues. It follows exclusively from his decision at first instance, and the outcome is the adjourned issues do not need to be determined. So this, we submit, is simply paragraph 286 of the trial judgment all over again. He's found one ground for liability. That's all he needed to do. And so he's just adding a recital, or including a recital, which is in good order, to reflect the fact that the adjourned issues are not covered, not addressed in paragraph 286. He's saying, I'm treating them the same. They do not need to be decided.
Well, what he seems to be addressing here is the distinction between the position as it is following his first instance judgment and the position that it might be following an appeal, and makes the point that that will be a matter for the Court of Appeal to determine.
I absolutely agree that that is part of his reasoning.
Well, if you're looking at the overall meaning of the words he ultimately used, you'd also have to take into account what he says at paragraphs 11 to 13.
Absolutely, I am coming on to those.
You can't look at the early paragraphs in isolation.
No, my lord is of course correct. Yeah, and I am coming on to those, but just
those are rather important.
They are important, but it is also important, my lord, to note that they're just about costs. This is about the form of the order. So they of course they're relevant, but they are relevant in a slightly different way. Because in these paragraphs, he purports to resolve the debate about what the recital should say.
Well, there are recording arguments about costs in the context of what he understands the substantive position to be.
Indeed they are. Indeed they are.
So it is rather important as to what the substantive position is.
I'm certainly not saying that one can disregard them in any way. And I will be explaining that I think the better view is that he does precisely the same thing with respect to costs. But I accept there are degrees of uncertainty about this. And the one uncertainty that passes through all of it is he just talking about the liability stage? Or is he actually seeking, when he discusses the need for the issues to be determined, is he seeking to circumscribe the quantum stage? And there's nothing in this judgment to indicate he is.
So,
moreover...
I'm sorry, I interrupted you midstream, but while I've done so, the prior orders, you say, adjourned these issues to the quantum stage.
Yes.
Not to resolution at the conclusion of the liability stage.
I think the prior orders left that open.
Right, and so it's been grappled with at this stage.
Well, so my submission on the prior on the liberty to apply in the prior orders is that they definitely allowed, that they cast a wide net, if you will, and they allowed for liberty to apply at the quantum stage, because that was in discussion between the parties in advance. That was precisely the eventuality they had in mind. So you must construe that liberty to apply at least that broadly, but I do accept that it was open to the judge to deal with him.
To return to it at that point.
My lord, yes.
And that's what you were asking him to do in your favour.
What we were definitely asking him to do was to make an order for costs in our favour in relation to the adjourned issues. It is my submission that in making that request, nobody grappled with anything resembling clarity about the liability quantum split.
Well, you've said at the outset that that was going to be a running theme from your submissions, and we understand the significance you place upon it. But I'm interested in the exchange you've just had with my Lord Justice Peter Jackson. And let me see if I can summarise where I think you got to and ask you if I've understood correctly or if I've misunderstood. You've pointed out the context in which the order of Mr. Justice Nugee and the order of Mr. Justice Marcus Smith were made. But I think you've accepted that the orders that were actually made were entirely open-ended.
Yes.
And therefore, at least in principle, a conceivable procedural consequence of those orders would have been 2 trials of liability.
Yes.
Although you make the point that another possible procedural consequence was that the liability issues would be dealt with on an inquiry or an account.
Yes. So
Right.
if I can put a bit of, perhaps answer that in a slightly different way, it must be possible that the infringement case at trial, the patent was valid and infringed by Astronics and Safran, but that the particular infringement cases that were brought to trial against Panasonic failed, and that left open the adjourned infringement cases against Panasonic, and those could have come back for a second trial, a second liability trial, before, independently of any quantum stage.
Yeah.
Or they could have been resolved at a quantum trial, because it is conventional for some issues of liability to be dealt with at quantum trials where it's convenient, and indeed that is going to be the case with our accounts. There are already a number of liability issues in play.
Yeah. All right. Thank you.
Can I just follow up on one aspect? I think you said that the position of the parties, and in particular, you were asking for your costs of the adjourned issues. But wasn't it also your position, as per the draft order, that you were at this stage only asking for liberty to apply insofar as may be necessary following any appeal?
So my submission on that, so I'm. Can I tell you where I'm proposing to go, and that may make things easier? In relation to the appeal from the Deputy Judge's judgment, which I'm nearly finished with, he didn't go to any of those materials because he said, I'm just going to look at the trial order and the relief judgment. But my second appeal is that the trial judge ought not to have made the trial order if it has the effect of shutting out the adjourned issues. And in relation to that appeal, I will be taking my lords to the materials before Mr. Justice Morgan for the purposes of relief.
But the Deputy Judge did refer to that in paragraph 38 of his judgment and said that the parties were agreed it was an aid to construction.
Absolutely right. So all I'm trying to tell you is that I'm going to be coming to that and explaining my position on the meaning of that order. I can do it now if you would prefer, but I'm not going to be missing it out. It may make more sense in the second appeal, but I obviously I have a common position in relation to it. And the common position is this, that the additional words were not limiting. It didn't have the effect of saying, you can only come back to this if there's a successful appeal.
Well, it seems to me it's all rather important because the thrust of your argument, it seems to me, has seen there's no reason why the adjourned issue should be dealt with differently to the unresolved issues. Yes. But it seems from the Deputy Judge's judgment that there are a number of matters which were demonstrated as distinction. One is what you were actually asking for before the judge, and the other was the judge, Justice Morgan's understanding that you had actually abandoned the adjourned issues. And those both are complete distinctions from the unresolved issues.
Absolutely. If the materials before Mr. Justice Morgan supported the proposition that Lufthansa is voluntarily dropping these issues, then plainly the adjourned issues sit in a very different position from the unresolved issues. Absolutely.
Yes. But the deputy judge was construing the order, the trial order,
Yes.
taking into account what Mr. Justice Morgan had said in his judgment, which is a primary aid for interpretation.
Absolutely.
So you do have to grapple with that, don't you, in relation to the deputy judge's order?
I do have to grapple with the trial, the relief judgment. Yes, indeed, absolutely, and I'm trying to do precisely that.
Thank you.
So where we had got to was in dealing with the first part of the relief judgment. What I had explained is our position is that having in paragraph 2 recorded some of the back and forth and the reasoning, the trial judge says with some clarity what he's going to do about it all, and in two ways he indicates that what he's going to do is identical to what he's done with respect to the unresolved issues. He says it comes straight out of his judgment and not out of something else. He doesn't say because you've made these representations or because your evidence says this. He says because of what's in my first instance judgment, and then he uses the words do not need to be decided. And that's, if you like, there's a default meaning to those words which comes out of paragraph 286, and it means at the liability stage. And that default meaning comes both from the judgment itself and from the decision of the deputy judge, paragraph 29.3. So far, I say there's a coherent interpretation of everything, which is that the trial judge isn't going in no way further for the adjourned issues than he had for the unresolved issues, although I accept my Lord's point that there have been some further materials before him, and he has discussed those materials. And then we can move on to the second part of the relief judgment, in particular paragraphs 12 and 13, which are set out and highlighted by the deputy judge. Paragraph 12, the trial judge records the defendant's submission that the claimant has not abandoned the adjourned issues. And at paragraph 13, he says that is not his understanding of the claimant's position. And I think that is the high water mark of the case against me. He doesn't say positively what he believes the claimant's position to be. He doesn't record any statement from the claimant in evidence or given on instructions to the extent relating to abandonment. He doesn't record that any such concession has been stated in relation to the quantum stage. But we do accept, of course, that there is an inference of some form of abandonment in his finding that he doesn't understand the claimant's position to be, that there has not been an abandonment. But once again, so we've got these various uncertainties, but once again we say the judge resolves in terms of action in the same way. He says, I will make an order to the effect that the adjourned issues do not need to be determined. And there is no daylight between that proposal and paragraph 286. It's the same outcome.
But 286 hasn't resulted in any order, has it?
It didn't need to result in a recite. Well, it has in effect, because it's the third recital which says, and upon the judgment being handed down. So that record of what's being done with with the unresolved issues is acknowledged in the third recital, and then the fourth recital comes along and says the same thing's happening to the adjourned issues. And it uses the same language in two ways, do not need to be determined in light of the court's judgment.
I may have misunderstood your answer to my lord's question, because his question was 286 didn't result in any order, and you say yes it did, but I'm struggling to understand why, because the third recital, which you pointed to, is an entirely neutral statement of a historical fact that the judgment was handed down on such and such a date.
Right.
Whereas the fourth recital is explicitly directed to the adjourned issues and not to the unresolved issues.
But there may be a lack of clarity in what I was saying. It doesn't... My position is that the matters resolved in the trial judgment, including where are we going with the unresolved issues, do not need a further acknowledgement than the third recital. The third recital calls the reader of the document to read the judgment and see what the outcome of those issues are, the outcome of all the decisions there are. And then the fourth recital deals with something that is mentioned nowhere in the judgment, and it aligns the destiny of the adjourned issues with that recorded in paragraph 286 for the unresolved issues.
Well, with respect, that's your construct.
My lord, yes.
You're constructing, if I may say so, very skillfully, an argument based on 286.
Yes.
That paragraph itself doesn't distinguish between liability and quantum. So you're already, as it were, I know you said the deputy judge approached it in that way. I understand that.
Yes.
But when one comes to the adjourned issues, as you say, it was not discussed at the trial. It's not found in the trial judgment. Where we do find it is in the relief judgment. And we find two things in that. One is that you had said that you might want to pursue this after a successful appeal by the respondent. And the other is, it's recorded that the defendants resisted costs on the basis that you were not abandoning, and the judge said his understanding was that you had abandoned. And that's where we get that's where substantive background reasoning, which explains what the phrase in the recital might mean.
I have to accept that it explains what it might mean. I mean, there is a reason here is that there's a lack of clarity, and my learned friend and I disagree about what it is. Just to be clear about 286, it's not simply, well, it's all a bit up in the air, but then I've got the deputy judge saying that. I go much further than that. I say it is inconceivable that in paragraph 286 of the trial judgment, Mr. Justice Morgan was deciding about whether the unresolved issues could come back at the quantum stage. That simply is no part of any of the materials that have been before him. Now, we're now in a position where we know the only candidate reason for the adjourned issues being beyond my client is an abandonment. No one is putting forward any case on abuse of process or strikeout, right? The only candidate is abandonment. There is not a whisper of abandonment before the court at the time of the trial judgment. So the deputy judge is absolutely right. It's not just that he's decided, he's plainly right. And so I've got that, I've made good that proposition. I'd like you to assume with me that that cannot be, there can be no whiff of abandonment. There's no pollution of the unresolved issues. They are rock solid. And that comes all the way through then. That informs every time you read, do not need to be determined. You can ask yourself the question, does that mean the same as before? But I have a default.
Well, they are actually different words. He didn't use the words "do not need to be determined."
No longer need to be determined. Do not need to be determined. I don't.
All
think...
right, but this brings us back to the question my lord asked you before, because an important theme of your submissions is that logically there's no distinction between the unresolved issues and the adjourned issues. But there is this distinction, because one of the questions that naturally comes to mind when trying to construe the order made by Mr. Justice Morgan is, well, why is it that the adjourned issues are singled out in the recital, whereas no mention is made of the unresolved issues in a recital? And what would you say to the following proposition, namely the explanation is straightforward. The unresolved issues have been before the judge at trial and have been discussed in the judgment. By contrast, the adjourned issues had never been before the judge at trial and were not discussed in the judgment. And that's why there's a separate recital addressing the adjourned issues and not the unresolved issues.
Oh, my lord, that is my case. I agree that's why there's a separate recital. Absolutely. Because you can't... You read the judgment and you ask yourself the question, what's happening to the unresolved issues? And you say, well, I know, because I'm told by paragraph 286. You don't get that answer in relation to the adjourned issues. So recital 4 comes to your assistance and says and tells you. You then ask, what's happening with the adjourned issues? And recital 4 tells you the same outcome for the same reasons. They do not need to be decided in light of the court's judgment. It doesn't say. Now,
But that's where what Mr. Justice Morgan said in paragraph 13 becomes important.
Right.
Because he'd said in paragraph 286 of the trial judgment what the position was in regard to the unresolved issues. And in paragraph 13, he's saying his understanding of what's the position now with regard to the adjourned issues, which had never been before him.
So let's consider what would need to be in that recital. We have pro tem agreed between us that abandonment's the only game in town in terms of the perishing of the adjourned issues. That recital would need to acknowledge that something's changed. There has been a development. It shouldn't be recital 4 where it is now. It should come after the reference to further submissions, and it should say this: and upon Lufthansa abandoning the adjourned issues.
That would have been better.
Well, it would have been better, it would have been clear, of course. But you see, there's an importance that would be attributed to a voluntary act of Lufthansa, and that was what was required. And so it's important that that's missing. The cause, when I addressed you on recital 4, I talked about the cause. If a party has voluntarily forsworn its legal rights, then that needs to be reflected in the order. Upon Lufthansa abandoning the adjourned issues, they don't need to be determined. Or upon Lufthansa abandoning the adjourned issues, then there's an order for costs. But it's wrong in two ways. It simply does not, on its face, record any divergence from the treatment of the unresolved issues. It's down to the court judgment, and they don't need to be decided. And although I accept that there is some friction with the relief judgment, it's much, much less than the other way round. There's a far more grievous omission in the trial order upon Lufthansa abandoning, on my learned friend's interpretation, or the deputy judge's interpretation, than on mine. Moreover, if we hadn't meant to abandon it, and we never used the word abandon anywhere, then without a hearing in relation to this, we'd have been straight back in front of the trial judge saying, something's gone badly wrong. We weren't abandoning.
Unfortunately, that leads straight on to anticipating the next application,
Yes.
which is that when you got the draft of Mr. Justice Morgan's judgment, you didn't go back to him saying, "This is an outrage. We've not abandoned these issues at all."
But my lord, that's because the view that we took the view that we did. I submit that reading that trial order and concluding that it has put beyond you certain legal rights that you possessed up to that time, it's not something that jumps out at you. I mean, it is, I call it veiled in the skeleton argument. The learned judge, the learned deputy judge says it's a sort of double implication. There's an implication in the recital and an implication in the absence of liberty to apply. I mean, I resist on behalf of my clients the idea that we should be criticised for not seeing that the judgment and the order had that effect. And we say that there is a much better interpretation of the judgment, which is consistent also with the trial judgment and more consistent with all the materials that were before the trial judge.
As I read the judgment, the overall effect is the judge is saying that his understanding is that you have abandoned those claims, save that you might need to restore them if the defendants were successful on an appeal, although he couldn't see how that would actually arise as a matter of logic. And that arises both from your proposed formulation of the order and for your position in relation to costs. And certainly, whatever you may say about the recital, the decision on costs, the ratio for that, was that you had abandoned the claims. So certainly I would have thought, reading that order, and in particular in the light of the draft that you had put forward, you would understand that he regarded the adjourned claims as abandoned and refused you the liberty you sought to pursue those claims following an appeal. And it's slightly perverse to think that you thought that he refused you that, but granted you a broader liberty to apply. So I really do have difficulty thinking that when you read that judgment and saw the order, you thought it's all guns blazing on the adjourned issues.
I mean, I think my lord has my submissions. I think my lord has understood my submissions. What you're putting to me is my learned friend's case that the judgment is clear against me, and I don't accept that. But I don't think I can.
And it's not right to press you on your subjective understanding. I appreciate that.
Not at this hearing, anyway. Yeah. I think I would be at risk of repeating myself if I.
Yes, thank you.
If I went back on that. My lords, I was going to move on to the second appeal, then, which we can take rather more quickly than the first. Yes. So this appeal is on the basis that the judge has held us to have abandoned the adjourned issues. I say that he oughtn't to have done so, because the materials before him did not allow him properly to come to that conclusion.
When we're talking about the judge from now on, we're talking about Ms. Justice Morgan, are we?
My lord, we are. I'll try and...
So, for the purpose of this appeal,
yes,
this application, we can forget all about the afters and the deputy judge and what the deputy judge did or didn't do. We're here as it were, considering an application for permission to appeal out of time from the original consequentials order.
My lord, yes, precisely.
So that's who the judge is from here
who the
on.
judge is, and that's which the judge, what judgment we're concerned with, and the,
right.
The trial order. So I've already explained. I think where we are at the moment is that whatever action the trial judge took must have been based on Lufthansa's own voluntary decision, And I say that would have called for an unequivocal indication from Lufthansa that it was dropping the adjourned issues from all stages of the proceedings. And that even then, procedural fairness would have required the judge to acknowledge that development clearly in the order that he made. As for the materials before the trial judge,
well, before we get into the merits of the argument, as you've already acknowledged, first there's the question of relief from sanction.
Yes. So
does that not logically come first?
Well, the reason I was going to deal with that second is because my case on relief from sanctions is based on the lack of clarity in the order and the trial judgment, and therefore I wanted to deal with those first in the context of the materials.
All right.
I'm not going to
take it in the order that you want. I mean, clearly, it is a prior stage for us, but you can deal with it in whichever order seems best to you.
To be clear, I'm not going to be taking much time with the relief from sanctions because my case is a simple one. We didn't understand that the order had the effect we now know it means, and we sought to get the dispute resolved in a timely and proportionate manner when it came to our attention. My Lords, the starting point is the trial judgment, and you've heard me at length on paragraph 286 of that, and that remains of a cornerstone of my position on the second appeal. To that, one needs to add, firstly, the witness statement from my instructing solicitor, which is in the supplemental bundle behind tab 12. This is where one would expect to find an abandonment by Lufthansa in the formal evidence served on the issues of relief. Starts in paragraph 2 by saying that the parties have reached agreement on all matters in the form of order, save for one point on costs. Now, pausing there, we know that's not quite right, because there were other issues on the form of order, but it does give you a flavour of the nature of the dispute, which is that those issues were themselves only arising in the context of the fact that the parties hadn't agreed costs. Paragraph 4, one outstanding issue in dispute, the parties have not reached agreement in relation to who should pay the costs of the adjourned issues. Paragraph 5 is the critical one. I'm picking it up in the third sentence.
Don't you need to read paragraph 4 from particularly the last sentence?
Yes. Indeed. So the paragraph 4 acknowledges how the adjourned issues came to be adjourned and what they related to.
Well, in particular, it said at the last sentence that they were alternative avenues of infringement. These simply represented different ways of running the infringement case.
Quite so. And then paragraph 5, my lords, is the key one. Records how some of these issues have been adjourned. And then Mr. McCulloch says this: in light of the court having held all three defendants' dealings in both the MPOW systems and the modified MPOW systems to have infringed Claim 1 of the patent, those adjourned issues are no longer necessary and accordingly have fallen away. See the fourth recital proposed by Lufthansa. My lords, that precisely aligns with paragraph 286. It is not saying Lufthansa has taken a decision. It is not saying that we have abandoned them. It is saying that in light of the court's judgment and nothing else, X follows Y. They are no longer necessary. There is, I submit, no daylight between that and paragraph 286. The cause of the expired necessity is expressly identified. It doesn't say he's got
Would you
instruction.
accept that one needs to read that together with the last sentence of paragraph 4, where Mr. McCulloch has said the adjourned issues simply represent different ways of running the infringement case, and therefore one understands that because you've succeeded on establishing infringement by all defendants, that's why the alternative, the different ways, to use his words, of running the infringing case were no longer needed.
Absolutely, my lord. But then that's precisely why the unresolved issues are not needed either.
He doesn't merely say they're no longer necessary. He also says, and accordingly have fallen away.
Right, but I don't read that as adding anything at this stage. I said the unresolved issues have fallen away at the liability stage as well. At this juncture between these parties, no one needs to call for a decision. But that is not saying anything other than this is the consequence of the judgment. We don't need we don't need you to arrange a second liability trial. We're fine where we are. It doesn't record an abandonment. It doesn't record a deletion or anything, any such.
But it says fallen away. The question thus arises as to how to deal with the costs of them.
Right, they have fallen away. It's in the past. This is not, we've got a judgment and we're taking a step in response to it. It does not set out there any voluntary action by Lufthansa. And if we are where I say we are, and you need to find a source for abandonment, that paragraph doesn't give it to you.
But why would the question of costs thus arise if those issues had not been finally resolved?
Well, that's precisely the point that the deputy judge dealt with. The question of costs is and I addressed you on it earlier. The question of costs isn't irrelevant, but it doesn't require an issue to be terminal before you address it.
It doesn't. But if a party is saying they thus arises how to deal, the point is being made. We have to now deal with the costs because there'll be no future time at which to deal with it.
Not that we have to deal with the costs, but this is a convenient time to deal with the costs, and it was, just as it was a convenient time to deal with the costs of the unresolved issues. As at this date, it was unlikely that any of these would have come back, and it's perfectly sensible for the trial judge.
Why was it unlikely then, but it's now important?
Well, it was unlikely then because if we'd chosen a damages inquiry rather than account of profits, it's difficult to see.
It was a consequence of your election that it became important.
It was a consequence partly of our election, and then a consequence of the way the defendants pleaded their position on the account. Absolutely, and none of this was foreseen at this time.
Well, the fact that we know it wasn't foreseen,
Yeah.
but could we contemplate a situation where you, freed of worrying about the small costs issue, had in fact been saying this adjourned issue is important to us and it has not fallen away? Let's suppose that had been, for one reason or another, your position at this point in time.
So if
let me just, because I'm working my way through this. And you'd said, therefore we need some directions about this adjourned issue. And you might have said, this is our case on that. They might have said, well, we won't contest that, or they might have said, we thoroughly disagree with that. At that point, the judge was going to have to be giving some directions for sorting out the adjourned issue, because it certainly couldn't be said against you at that point that you had abandoned it.
Indeed.
Because on the contrary, you were making use of the intervening orders, or the prior orders, to bring it up. And so at that stage, one would have expected that something would have been done about those issues, and the judge would have given some directions, and we'd be in a different world.
Agreed.
But when we come, as I imagine we will shortly, to look at your submissions to the judge, not just the statement underlying it, that wasn't it at all. That wasn't what you were saying at the time at all. And you appear to me to be now arguing for some middle position, which was that we needn't either suckle our claim or seek to bring it forward into the world. We can just sort of let it sit there and then say later, well, we never said we weren't wanting to pursue it. I mean, wasn't this the moment, if you were going to treat your claim seriously, to actually say, well, when we may not be asking you to rule on this now, Judge, but we'd like you to timetable this for a subsequent disposal and direction.
We didn't at this stage want any such timetable. We had no cause to press for resolution of either the unresolved issues or the adjourned issues. The sensible case management route through this, and let me just put a pin in the trial order, but what ought to have happened as a matter of the machinery is we go off to the appeal's dealt with, then there's the appeal was dismissed, then there's an election between the damages and profits, there's the pleadings, and then the parties are free to raise whatever issues of liability are relevant to the quantum stage in light of the pleadings. The impediment to that ideal scenario is that the trial order did not record in terms that the unresolved issues and the adjourned issues should be available at a quantum stage if required. That would, of course, would have dealt with everything. In relation to the unresolved issues, that's not a problem, as per the decision of the deputy judge. In relation to the adjourned issues, it has become a problem. But the machinery is the same either way. I wouldn't have needed to ask for resolution of those issues independently of the quantum stage, because I had all I needed. I had an order for an inquiry or an account. And in the normal way, I am free to add some additional liability issues to those hearings, as recorded in the judgment of the deputy judge by reference to the law set out there, the AP racing case and its associated cases. So it would just be conventional. Now, in terms, I think it might help to think of the range of potential futures for the adjourned issues as at this date. There could have been, on the one hand, an abandonment. They're never going to come back on one side of the range. And
that's pretty much what you said in your
skeleton argument. That's the case against me.
Well, no, it's not the case against you. It's your case. In reality, the defendant's proposal will mean the costs of the adjourned issues are never revisited.
At the other end of the range, there is we're definitely going to need these, and we're going to need them soon. So let's have some directions. The point my Lord Justice Peter Jackson just put to me. And in between those, there's uncertainty about whether there's going to be any utility, any relevance for the issues in the future. And we are definitely in the middle somewhere. And you can certainly say, as you're putting to me, that we're closer to one side of that range because we didn't make it as clear as we might what's going to happen in the future. But at that stage, we didn't know what was going to happen in the future, and people weren't considering that future. They were considering the liability stage. And in relation to the liability stage alone, the conduct was unproblematic.
Can I ask your help on this in relation to costs issue across the board? You, understandably again, say, well, the position is the same in relation to the unresolved issues, and those costs were dealt with. But it seems to me that there is a very significant distinction. As I understand, tell me if I'm wrong about this. The unresolved issues were before the judge at the trial, were argued before him, and all the costs were incurred in relation to those issues. He ultimately decided it wasn't necessary to determine them. But it was necessary for the trial judge to deal with those costs. The matters had been argued before him, and as I understand it, the defendants didn't oppose you having those costs. There was no issue.
So if I can take those two parts separately,
Yes.
absolutely right, the defendants didn't resist those costs.
Yes.
I don't accept that the judge was bound to deal with them, because if we go back to my
Well, he could have reserved them or made a yes, but he had to make some. The costs were incurred in relation to the trial before him. He had to make some disposition.
My lord is right. The incidence of those costs was an issue before him. Yeah.
But that was not the case in relation to the adjourned costs. Those issues were simply not before the judge.
Well,
and so if he was then going to make an order for you to have those costs, there was going to have to be a clear basis when nothing had been argued before him in relation to them, no evidence, no arguments in relation to the adjourned issues, for giving you your costs of the and it seems to me that that's why it's a fundamentally different situation. And unless you had at that stage given some indication that the time for determining those costs was now, and the basis for it, seems to me the judge wouldn't have had any reason to deal with those costs. And the basis for that was the statement in the witness statement, effectively, Mr. McCulloch, that these were only alternative arguments. They were no longer going to be pursued, except possibly following an appeal, and therefore we want our costs, please.
so I don't accept. I mean, I understand precisely what my lord is putting to me, and I do say I do accept there is a difference, but I don't accept the difference is quite at that level, because these were still costs incurred in the progress of the liability trial. They might easily have been part of that trial. They weren't as a result of the pre-trial adjournments, and it was a proper exercise of the judge's discretion to deal with those costs, even in circumstances when the issues might come back. And in that regard, they are qualitatively the same position as the unresolved issues, in that they are not, it is not established that they will never come back. So if I gave you the range of possible likelihoods.
What would the judge have done if you'd said, well, we'd like to think about this. We need to see how things pan out, what we elect to do, what issues are then likely to be necessary to be pursued. We'd like to think about this, but we'd like our costs of the adjourned issues.
Yeah. So what would have...
What would the judge have done?
I can guess. I will answer that question. So I think what should have been, plainly should have been clearer in our presentation to the trial judge is that we were only considering this stage of the proceedings, and we weren't seeking to bind ourselves in any way in relation to quantum. And let's assume, so let's assume that had been
That's
made
one
clear.
stage. That's the setting.
Yeah, that's the setting. If we'd said that, I think it's perfectly reasonable to expect the judge to have dealt with the costs in the same way. It may so. My primary position on the interpretation of the trial of the relief judgment is that he's only considering the liability stage. If you just imagine a sentence at the top that says, "I'm only considering the liability stage," and everything that follows in that context, and so when he talks of abandonment, it's just about the liability stage. Everything else follows through, and so that is my, as you know, I said from the very beginning, that's the sort of context which I urge upon you. And the problem is that context, whilst it emerges from a number of the documents, in particular from the trial judgment, the language that's used in para 286, it's not then expressly deployed before the judge at the relief hearing. And if you don't take that as the context, then we end up with these difficulties. And if you're against me on that context, I accept that we are in some difficulties.
Yeah, so your essential submission boils down to this. You say that the position was ambiguous, and that ambiguity should not be held against you to preclude you advancing what may be good claims.
That's correct.
It's a bit reductive, of course.
But so that the qualification I would put on that is that the ambiguity is also resolved by the trial judgment. And so I put an onus. I start with paragraph 286, which says we're only in the world of the liability stage here. And I say there's nothing adequate to reframe that context that happens subsequently. But of course I accept that there is some ambiguity, and it's my position that that ambiguity should not result in the claims being struck out. And I submit that, given that the ambiguity is said to reside in a representation by my clients as to abandonment, that would have needed a clear and unequivocal statement, and that there's nothing to be found to that end in the materials. Now, we were in the witness statement, and I tried to stress that the have fallen away, and the reference to the court's decision in paragraph 5 is properly to be construed as consequences that have already taken place, independently of any involvement by Lufthansa or any instructions by Lufthansa. These are said to be outcomes of the judgment. And we say that one gets the same from, if you turn forward please to paragraph 18,
Run me with the page.
yes, sorry, page 104 of the supplemental bundle. So 18.2 deals with one of the adjourned issues. This is joint tortfeasance between Astronics and Panasonic. And Mr. McCulloch says, in the end, Panasonic was found liable, the supply of a kit of parts, and in these circumstances, the joint tortfeasance argument, which provides an alternative route to the same result, was not needed. Again, that's backward looking. It says nothing about we are moving things on, we are abandoning it. It wasn't needed for that judgment, for that trial. And to the same effect, the end of paragraph 18.3. This is all consistent with it being a statement of what followed inevitably from the judge's judgment, and not because Lufthansa has now interfered in some way and taken some step to its detriment. My Lords, Mr. Bennett gave the corresponding statement for the defendants. That's at tab 13, but I don't think you'll find anything relevant in it. It identifies the only issue as cost as well, but that aside, I'm not sure it helps with this point. Then we have the defendants' submissions, which are behind tab 11. You'll see at paragraph 3, the dispute on relief goes to costs. And then in paragraphs 9 and 10, I'm going to submit to you that these are ambiguous in relation to my first dichotomy. Importantly, they've read Mr. McCulloch's statement now, and what they complain about is that, well, the issues have not really fallen away. Lufthansa has not felt able to indicate that it's giving up the adjourned issues. They are to be kept up Lufthansa's sleeve. It hasn't succeeded because they haven't been heard. If an appeal succeeded in part, Lufthansa seeks to keep these issues in play, so it could run them at a later date. and it may succeed on them or it may lose. Again, no express reference to quantum. On the contrary, if you read those two paragraphs together, and in particular together with the reference to an appeal, it suggests that everyone is still only thinking about the liability stage. The Court of Appeal might take a different view on the interpretation of Claim 1, and you might have to come back for some reason. That's what the party is talking about. No one was saying there's a representation here about the whole proceedings, about the quantum stage. And then paragraph 13 and 14, again, the issues have not fallen away. Paragraph 14, the court has not heard these issues and Lufthansa has not abandoned them. So they've read Mr. McCulloch's statement, and what they take from that is they haven't been abandoned. I mean, at this stage, they're absolutely right. Now, in our written submissions, again, I accept that these are prey to greater ambiguity, but they are advanced in the context of Mr. McCulloch's statement, and Mr. McCulloch's statement that on behalf of Lufthansa we are dealing with the immediate consequences of the judgment. Paragraph 1 again identifies the only issue as costs. Top of page 84, this is talking about the adjourned issues. Following judgment, it is no longer necessary to resolve them. Again, there is no daylight between that and paragraph 286 of the judgment. Following judgment. Then paragraphs...
Well, is it not necessary to read that a little bit in context? So the preceding sentence says, for reasons of procedural efficiency, they, that's the adjourned issues, were put to one side unless and until they became necessary to resolve them. Following judgment, however, it is no longer necessary to resolve them. That means never, doesn't it?
Well, again, I mean, I have to give the same answer, which is that everyone's just thinking about liability, and this isn't this isn't a statement that.
So at every point where these statements are made, one should read in at this stage of the proceedings.
That is the inherent context which I say is applicable, my lord. Yes. Paragraph 9 records in terms that the action was split between liability and quantum, and that Lufthansa has won on quantum, excuse me, on liability alone. And then in paragraph 11 is important.
Just pausing on paragraph 10, all the adjourned issues go to liability.
Yes. They do go to liability. It's just that some liability issues can be relevant at the quantum stage, and that is what has happened subsequently.
You're on paragraph 11 now.
My lord, yes. So paragraph 11 then draws an express parallel between the adjourned issues and the unresolved issues. Says that we agree an exception to the general cost rule applies when there are specific, suitably circumscribed issues on which the overall winner has lost. And it gives an example of Claim 7. That exception does not apply to issues on which Lufthansa has not lost. Such issues include not only the adjourned issues, but also issues concerning the infringement by equivalence, kit of parts, etc. These are all unresolved issues. These three latter alternative infringement cases were each pleaded and argued at trial. The judge declined to deal with them, and preferring to leave them for a case where they need to be addressed. No criticisms are made by either party, and the defendants do not resist the cost. Then at B, this position is in our submission no different in relation to the adjourned issues, in that it similarly has not been necessary to decide them in order to determine liability. So my learned junior was saying in terms that they didn't stand in a different position. Now, where I am today, I'm told that I can pick up, it is in accordance with justice and convenience for me to be able to reprise the unresolved issues. And yet in circumstances when Lufthansa's submission was that there's no difference as between them and the adjourned issues, I can't touch the adjourned issues. My learned friends are enthusiastic about paragraphs 16 and 17.
Before we get to those,
yes,
should we not note what said at 13? Fifth, as Mr. McCulloch explains in some detail, the adjourned issues were each alternative ways of putting the infringement case to address the various defences raised.
Yes.
And so that's the explanation as to why Lufthansa does not think that they need determination, is it not?
Right, but my lord, again, precisely the same applies to the unresolved issues. In the context of the liability stage, this is all correct. We don't have, these issues are now without utility. And it's sensible to deal with their costs because this is where we are. But what is not being said is, outside that context, we never come back to them. Again, there is no distinction being drawn in our submissions between the treatment of the unresolved issues and the treatment of the adjourned issues.
In practice, if it was within your power to rely on the adjourned issues, would there have to be a further trial?
No.
How does it work?
No. So as it currently stands, both sides have pleaded quite extensive issues of patent infringement liability in the quantum pleadings. Some we're allowed to because they're unresolved issues. My learned friends are running a non-infringing alternative defence. They are saying, you don't get any profits because we could have manufactured and sold a different product which would not have infringed. And that proposition, that the different product would not have infringed, is itself controversial. So the trial in October 2024 will already have a significant number of infringement issues being resolved.
Although as a matter of case management, an alternative approach would be to split that trial into two and deal with infringement issues first and financial issues second.
That certainly is a possible outcome or case management outcome, absolutely.
Yeah.
But to be clear, even then, the quantum issues, so the liability issues are those that arise, they have a quantum flavour. So, for example, it would be the non-infringing alternative would have no relevance at a liability trial because it doesn't matter whether you could have done something differently or not. What matters is whether you did in fact infringe.
Yeah.
But on your analysis, what you would have needed in due course, potentially, were directions for these to be determined at a quantum hearing, the adjourned issues. And that's where paragraph 16 comes in, isn't it?
So I didn't quite hear everything my lord said.
Well, what I said was that on your analysis that everything was backward looking to liability.
Yes.
On your position, you would at some stage have needed directions for the adjourned issues to be determined at the quantum hearing.
If they were resisted, so if the trial order had adequately recorded that the issues remained available, then they would have been pleaded to the extent that they were required, and in the points of claim and the points of defence.
No, I think my lord's point is a little more basic than that.
Sorry.
As you've pointed out to us, the orders that were made originally refer to the issues to be adjourned generally,
Yes.
with liberty to apply.
Yes.
So, formally speaking, to bring them back, a liberty to apply needed to be needed to be an application for permission to revive those issues needed to be made. Otherwise, they would stand adjourned forever.
I understand the point that the answer is not a straightforward yes, because the learned deputy judge has held that Lufthansa was entitled to reprise the unresolved issues without any liberty to apply.
That's because they were never adjourned.
Right. So
procedurally there's a difference. It may not make any difference to the substance, but
yes.
procedurally there is a difference.
Well, can I answer that? Possibly, because if one considers that liberty to apply is not needed, which is the consequence of the deputy judge's decision, and in other words, if there had been no liberty to apply, it didn't fetter me in relation to the unresolved issues, it could be said to follow that an application is not needed.
I don't understand that, because we're not talking about the unresolved issues. We're talking about the adjourned issues, where you've made the point, correctly as it seems to me, that the orders were made for those issues to be adjourned with liberty to apply, and they were adjourned generally.
Yes.
And therefore, to bring them back into play, an application needed to be made, formally speaking.
Right. So I absolutely accept that it was open. In those circumstances, it is open to apply within the provinces of that liberty to apply. The reason I'm not giving an unqualified answer is because if one follows the deputy judge's reasoning that you didn't have to have a liberty to apply, then that could be said to mean you don't need to make an application, even if you have the benefit of a liberty to apply.
Now, the moment
he has said you're free to take them up because justice and convenience allows you to, and it doesn't hinder that outcome that you have no liberty to apply.
But at the moment, we're considering the position as before Mr. Justice Morgan, well before the deputy judge came on the scene.
Yes.
And we're looking at what you have to say, it seems to me, or what you are saying, is that the judge was wrong on the materials before him to find that you'd abandoned the adjourned
My lord, yes.
issues. And in paragraph 16, on your client's behalf at that stage, it was being said that the only direction that a party will seek is for payment of its costs.
My lord.
And that means that the adjourned issues were never going to be pursued.
So, my lord knows my answer to that proposition is that in the context of the evidence, the judgment, etc., this is a submission that is of application only to the liability stage.
We need to be looking 16, 17, and also, I'm sure the rest is important as well, but 29 and 30.
Absolutely. My lords have the point. You've read the submissions.
Yeah. So you're in the rather uncomfortable position of saying that the judge was wrong to fairly much accept what you were saying. But your argument is that you weren't saying what you appeared to be saying.
Well, it's a little bit more nuanced than that, which is that these submissions were not made in a vacuum, and the context helps to resolve the common ambiguity about the extent of the submissions that are being made, and it resolves it in favour of them relating only to the liability stage. I wonder if that's a convenient moment.
All right. How are you getting on?
So I am progressing well, and I will be finished within the next 20 minutes.
Thank you. 2 o'clock.
No, well, I was doing fine.